one.
Okay, good morning and welcome to the State Ethics Commission. Today is November 19th and the time is 9 o'clock. First on the roll, let's do a roll call vote. I'm sorry, a roll call, huh? Not a vote. Attendance.
First, starting with Commissioner Hong.
Present remotely.
Commissioner Thielen. Here. Commissioner Becker. I'm here. Chair.
Chair is here. We have a quorum. Just one administrative announcement. Turn off your cell phones if you have cell phones on. And also, if you need to be recognized, especially on a WebEx, raise your hand so we can recognize you. I see that we do have individuals who are joining us, and I'm going to ask Robert to read the caveat.
Let's see where second. Aloha, my name is Executive Director Harris. Even though this is a in-person meeting, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting, which will be posted to our website and used to create official minutes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit this meeting now. For any members of the public who may be joining us remotely, if the Commission's video conference connection is lost during the meeting, we will recess the meeting and reconvene after our connection is restored. Please check the Commission's website, ethics.hawaii.gov, for information about reconnecting to the meeting. If the meeting is continued to a later date or terminated, information about this will be posted on our website. Are there any members of the public joining us who would like to identify themselves at this time?
Any members of the public want to identify yourself?
Judith Mills Wong with League of Women Voters. Thank you.
Okay, well, welcome. Anybody else? Not? Item number 1, consideration and approval of the minutes of October 5th. Any corrections to the minutes? If not, I'll entertain a motion.
I move it. I move to approve them.
Before I do that, I've been reminded, are there any comments from the public in regards to the minutes? Okay, not, I'll entertain a motion. Go ahead.
I move to approve the minutes.
Is there a second?
Second.
Second, moved by Commissioner Thielen, seconded by Commissioner Hong. Any discussion? Not, roll call.
Commissioner Hong.
Aye.
Commissioner Thielen.
Aye.
Commissioner Becker.
Aye.
Chair.
Chair votes aye, no objections, motion's carried. Director's report.
If I can turn this portion over to Benita.
Good morning, Commissioners. Just a brief update for our education disclosures. As we approach the end of the year, we have one more webinar training scheduled in December for MCLE attorneys credits, government attorneys. That's scheduled in early December. And in terms of updates to the the education materials, we're going to be working on that. There is a new law that's kicking in to ensure ADA compliance and accessibility for website content. So we want to make sure that the self-guided modules are fully compliant. It is, as far as we know, but we just want to go through the process and update it accordingly. So that's going to take a little bit more time than we originally scheduled. So we'll be working on that and updating the commission accordingly. But generally, that's pretty much the main report that I wanted to provide for the commission. If you have any questions.
Any questions from the commissioners? Any questions from the audience? Next.
Commissioners, also, if I can point out that attachment 1 and attachment 2 include attachment 2 is the proposed 2026 training schedule that we'll be following. If I can turn the guidance and assignment statistics over to Keith, our enforcement director.
Okay, so basically 31 complaints opened in October, 26 closed, so roughly closing what we open. And then 330 year to date opened, 299 closed, so pretty good. And then in terms of what's on deck for us, we are going to be looking at closing assignments that have been consolidated. So a lot of times we get, complaints that are related. So I suspect we should be able to inventory those and make sure that those are all closed by the end of the year. And then additionally, we're working on enhanced statistical reporting. So hopefully by the January meeting, we can have a good idea of what that's going to look like.
31 opened and 24 closed, something like that.
26.
26 closed.
Yeah.
Why the
Well,
rapid? I mean, I'm happy to see a rapid turnover, but why the
yeah.
rapid turnover?
Oh, well, I think doing the first pass, so I think numbers like that are common. Doing the first pass, a lot of times is referring people to other governmental agencies. So if the complaint is not about a state employee or about something we don't necessarily have substantive jurisdiction over, we're trying to refer that person to the appropriate agency. So that's, a lot of it. And then we do get several complaints a month that warrant additional digging. And that's when Jared is, interviewing people, doing open source information searches, that sort of thing. So I think that's a typical breakdown, I would say. Yeah.
So, in general, if they have a complaint against the government, the first agency they turn to is ethics.
Um,
Seems like.
I think, people will complain to multiple agencies. I think us, OIP, the ombudsman's, we all are good government agencies, so we receive related complaints. And then, the members of the public don't necessarily know which agency does what. So trying to make sure that those people are pointed in the right direction so their complaints can get addressed is, what we're doing on the first pass. Yeah.
I'm glad that everybody has his fair share of complaints, that's all, not just
Yeah.
us. Any questions or comments from the commissioners? How about the public? Not three.
No miscellaneous reporting there. No miscellaneous office projects or updates.
Okay, item number 3, or the discussion of media reports.
As a reminder, this is a standing item on our agenda, which gives the commission an opportunity to talk about any media reports discussing ethics within the past month since our last meeting. Briefly, as a quick survey, we have a November 17th article in Hoodline, which focuses on the Ethics Commission taking aim, pay to play, and political family perks. November 16th, we have a Civil Beat article, which is very similar, and it almost looks like the November 17th copied it. Civil Beat did an article on fundraisers to favors. Ethics wants to crack down on state workers, so it basically covers the 3 legislative proposals that the commission discussed at the last meeting. November 11th, Hawaii Free Press is talking about a letter sent by Representatives Pilati and Souza that was sent to AG's office, campaign spending, and the Ethics Commission. November 10th, Hawaii News Now is also reviewing similar letter, but it's basically looking at the investigations into the allegations that the feds are investigating a legislator that took money, and then essentially we do not know who the name of that person is. November 9th, there is a Civil Beat Sunshine blog overview of the enforcement case against Senator Roy. Similarly, November 9th, there's an article noting the passing of former trustee Akana. November 7th, there is a OHA statement on Akana's passing in Hawaii News Now. Similarly, the Civil Beat also had an article about that. November 5th, there's a Hawaii Public Radio overview of the enforcement case against Senator Roy. October 31st, there's a rolling out story on alleged petition investigating, asking the legislature to investigate the federal investigation. And then October 27th, Ian Lynn did an article. The Maui Ethics Board had adopted rules that prevented people who filed a complaint with the Ethics Board from talking about their complaint. And Ian Lynn pointed out that such gag orders are unconstitutional and pointed to past history, including past history at the Hawaii State Ethics Commission.
This one note, it got brought to my attention, especially reading in a newspaper. It was a lot of, I guess, inquiry in regards to, and it's called federal probe still active following conviction of the Hawaii lawmakers. Mentioning the fact that, for commissioner's information, we got a request by Bellotti and also Nakamura in regards to what are we doing? Well, actually, what is the state doing? And campaign spending and also the Ethics Commission. And we did respond to the legislators, but what was really important is what was said in the newspaper. And I'll read it to you just to make sure we're not look like we're shirking our responsibilities. When Nakamura wanted to know if separate state investigation would interfere with the work of federal agents looking into the allegations of corruption. We're talking about the subject matter. Yeah. And quote, the Sorensen responded, he's with the Justice Department, at this point, a parallel investigation by state authorities would potentially interfere with our investigation. And with that caveat in mind, we're just going to wait and see what happens. Is that correct? Okay, so nobody can say, "How? What are you guys doing? What are you guys doing?" Sarah. No, we have to. With that caveat, I think we're going to wait and see what happens until it's at an appropriate time we can act. Is that correct?
Again, under our statute, we're not allowed to talk about our investigations. So, it's not something normally we talk about publicly. We have publicly indicated that if we have information about a violation of ethics code, we will enthusiastically investigate it and enforce it.
Okay, good. Thanks for the clarification. Any comments from the commissioners? Any questions or comments from the audience about what I just read? Okay. Moving on, item number 4, discussion of possible legislative proposals within the commission's jurisdiction.
Thank you, Chair. We previously talked about several bills which the commission approved. These are, so we have one bill that was discussed at the last meeting that commissioners had asked us to work on some more, which is, so it's now revised, we're going to consider it. And we have 2 new proposals here. The entirety of the things that the commission approves will become a part of our legislative package. So the reason why you don't see past bills discussed, they've already been approved. They're already waiting to be submitted to the legislature. So these are 3 new ideas that we would like to discuss with you and get your feedback on. And if you decide to approve them, they would then be part of our package. The first bill, which is attachment 1, is a proposed bill restricting state employees from taking official action on pre-employment matters and amending the post-employment law. The so-called revolving door with folks coming in and out of state service attempts to address it, usually look at both post-employment and pre-employment. And so this is modeled loosely on a federal version of similar concepts. So based on the discussion that we had at the last meeting, this expands the prohibition on being involved in pre-employment matters to 2 years. And it expands the definition of what is a matter people are involved in. And it is loosely based on the Federal Hatch Act. So we are trying to ground it in that specific. This also, and this is something new, it was discussed last time, expands the post-employment to include restrictions to include members of both the governor's and the LG's office. There are key policy folks that are, at both offices that previously were not subject to the post-employment law. And so when they left the governor's office, they essentially did not have to oblige by the restrictions in the post-employment law. And so we were trying to include that as sort of a logical connection. We pause there.
Questions from the commissioners? Any questions? Any questions from the public? If you want to do this one at a time,
I think it makes sense.
okay, if you're not,
It's actually a good questions.
yeah, go ahead.
Are there restrictions on like current employment? You know, so if you are one of these people who have a side job, or is that already disallowed?
So there are restrictions on the governor from having secondary jobs. There are treatment restrictions on having a side job that would create a new conflict of interest. So if it's directly overlapping with your responsibilities or duties, then yes, that would be a restriction.
Okay.
But for example, somebody wanted to work at the farmer's market on a weekend or something, there would be no restriction on something that's completely unrelated to what they're
So
doing.
that's sort of covered already. So when it says like up until the point you sever the relationship, you couldn't keep the relationship when you become a state employee.
If you have an existing conflict of interest that you are continuing at the time of employment, that usually has to be disclosed and known. And you'd be prohibited from taking official action involving that existing conflict of interest. You are not allowed to create new conflicts of interest.
Okay. All right, so I'm just wondering if there's like a technical, because it says like you sever the relationship and then you become an employee, but what happens if you don't sever the relationship? So, just a question, I don't know if you want to just kind of think about whether that impacts anything.
The intent here is really focused on employees that enter into state service who have severed a relationship. So it is no longer a conflict of interest.
Okay.
And, currently conflicts of interest, if you have an existing relationship, we create a prohibition. But employees that leave private service and enter a government service, the intent here is to create a cooling off period. Essentially to say your relationship, your private employer is still new enough, it's known enough that there should be some type of cooling off before you're allowed to take action involving those private employers.
And then just one more on this one. So the permanent employees of the office of the governor and lieutenant governor. So the term permanent, what does that mean? Because it doesn't say permanent for most of these other folks.
The intent is to not pick up casual hires or folks that are, sort of temporarily entering and exiting. I think there is a history on that, but I'm not as familiar with the history. I can ask other staff if they want to jump on that, but the intent really is, full-time positions, not somebody who's coming as a casual hire or somebody who's coming in as a consultant.
I can briefly, sorry.
I'm sorry, who's this?
This is Bonita. I can just briefly address that language is picked up from the disclosure law. So some of the language, you want to mirror other sections of the code for consistency. So the permanent employees, other than those that are, clerical roles, is the specific wording is seen in other aspects of the code. So it's to kind of have continuity.
Okay. Any other questions from the commissioners? Good questions, by the way. Any comments? Out from the public, any questions or comments for this particular proposed bill? Okay, if not, I'll entertain a motion that we approve the proposed bill restricting state employees from taking official action on pre-employment matters and amending the post-employment law. Moved by Commissioner Thielen. Is there a second?
Second.
Seconded by Commissioner Hong. Discussion? If not, roll call.
Commissioner Hall,
Aye.
Commissioner Thielen,
Aye.
Commissioner Becker,
Aye.
Chair.
Chair votes aye, no objections, motion's carried. Second proposed bill.
Thank you, Commissioners. This bill would expand the number of boards who publicly file. And this is based on looking at boards that have substantive fiscal or financial or policy decision-making. It also includes the executive directors or executive officers of the current existing boards and commissions who publicly file and the newly proposed ones. Again, the thought process is the same, that the executive directors and executive officers usually have a lot of delegated authority. So similarly should be publicly acknowledging if there's potential conflicts of interest.
Questions, comments from any of the commissioners? Any questions or comments from the public on this bill? None, I'll entertain a motion that we approve the proposed bill. Expanding the categories of board and commission members required to file public financial disclosure statements. Moved by
I move.
Commissioner Thielen. Is there a second?
Second.
Second by Commissioner. Thank you. All right. Becker, any discussion? If not, roll call.
Commissioner Hall,
Aye.
Commissioner Thielen,
Aye.
Commissioner Becker,
Aye.
Chair.
Chair votes aye, no objections, motion is carried. Item number 3, proposed bill requiring nominees, etc.
Thank you, Commission, and thank you, Chair. This bill would require all nominees who are subject to Senate confirmation to file a public disclosure before that commission hearing. The intent is to give the public an opportunity to see the filings and for any potential conflicts of interest to be discussed publicly before the confirmation. It would also require those folks, most of them who already do file publicly, to also continue filing publicly thereafter. It also makes some, I wouldn't call them non-substantive, but some technical amendments overall to the financial disclosure bill for consistency and clarity.
I have a question. Aren't they doing this now? I mean, heavens, before you go before Senate confirmation, wouldn't they do a background check and conflict?
Yeah, thank you for that question. It's a good one. Currently, the Senate can request information from nominees, but only the Senate is the body that sees that. It's not necessarily made publicly available, nor is there necessarily a mechanism to enforce, false statements, misstatements, omissions. The intent here is to require the same information that already be filed, simply to make it available before the confirmation hearing. So that way, members of the public can see it, and that becomes a part of the confirmation discussion. But also we have the ability to pursue fines, for example, if there are material misstatements or misrepresentations. So we create a kind of an enforcement mechanism. The hope is the same information is already being gathered and will be made public, but the idea is to do it certainly before the confirmation process.
I guess my more pragmatic question is to find out that he lied in regards to this pre-nomination. And we go ahead and find him. Does that mean he's and he gets confirmed? Does that mean that jeopardizes his confirmation?
I think if there's a mechanism for a body, whether it's the governor or the Senate or something, to discipline or remove, they certainly still have that ability. But I think we would still now have an actual enforcement mechanism. I think there have been past situations where the Senate has acknowledged certain questions weren't asked or certain information wasn't provided. This intent would be to create a uniform request of information that would be made publicly available.
So the public will know beforehand, so they can testify at the confirmation hearing. That's the bottom line.
Right.
Any other questions or comments from the commissioners? How about from the audience? Any questions or comments? Okay, then I'll entertain a motion that we approve the proposed bill requiring nominees to positions subject to Senate confirmation to file financial disclosures before their confirmation hearings. Moved by Commissioner Becker,
Second.
second by Commissioner Thielen. Any discussion? Okay, roll call.
Commissioner Hall,
Aye.
Commissioner Thielen,
Aye.
Commissioner Becker. Aye. Chair.
Chair votes aye, no objections, motion is carried. Thank you. Next on the agenda, item 5, proposed budget.
Correct. Thank you, commissioners. The proposed budget does not make any significant changes, so it's generally reasonably consistent with past budget proposals. So I'm not going to go into any sort of non-changes. There are changes based on increased costs. Apologies, I'm pulling it up myself. Increased costs to some of our related expenses like attorney registrations, et cetera. Probably the biggest expense that we're flagging here is based on 2 different concepts. One, as Benita referenced earlier, there are new accessibility standards which we actively want to meet, which will require us reviewing essentially all of our website materials, our training materials, and our future agenda materials to make sure that they are properly notated so that anyone who has accessibility issues has the ability to access the information with minimal hassles possible. In addition, a number of commissions have started developing private AI bots. Essentially, they are only accessible within the commission. They're not publicly, the information or requests are not made publicly available, that have been used to help answer questions. And we're looking at that specifically to help with the sheer number of AODs and travel requests that we get, that would essentially help create a first draft response that then can be used by the attorney to help provide information. It would increase, hopefully, speed, efficiency, and consistency among answers over time. So those are proposals. They may get rejected, but the idea is that's what the additional expenses primarily focus on.
Any questions by the commissioners? Comments? I got a
That's
question.
just small,
Yes.
please. Just a small question. So the budget increase is by $12,000, but there's a $20,000 increase in computer services projected. Is that balanced off by something else that I didn't quite see?
Yeah, so for example, we're reducing the office furniture and equipment. There are some decreases in the overall rental amount that we are paying for our space. So there are some decreases. The overall amount is a net of a 0.8% increase.
And computer services were related to the issues that you just described. Is that correct?
Correct. Computer consulting, correct.
Thank you.
That was my question. So the biggest item increase would be the computer consulting then.
Correct.
So everybody will be up to date in AI.
Well, I think the focus would probably be first and foremost on accessibility. And we do not have a firm grasp of what that may or may not cost to hire someone to help with that accessibility. The secondary expense would be potentially trying to develop an in-house AI bot. Again, we're not developing AI ourselves. We are essentially using a commercial service, but the idea is it only use information in-house and the information would not be allowed out publicly.
It was actually it's an increase of about 20 grand in regards to, so maybe it's more pragmatic, but do we really need AI?
We don't. Again, we are getting more and more enforcement cases, attorney of the day cases, et cetera. The idea is if we can submit a inquiry into an AI bot and have a pre-drafted letter already created. The idea is we can then have an attorney review that, make sure it's correct and accurate, and send it out, it could really expand, speed things up, make things more efficient, and hopefully you get more consistency among all the different advice letters going out.
I can personally attest to the AI. In my teaching at the university, you ask the students a question, they press AI and they got the answer without even, anyway, that's another story. Any other questions or comments? All right,
Move approval.
yeah, Robert?
Move approval.
Oh, move approval. Is there any comments or questions from the public? Okay, there's a motion to approve the proposed budget. Is there a second?
Second.
Second, moved by Commissioner Hall, seconded by Commissioner Thielen. Any discussion? On roll call.
Commissioner Hall.
Aye.
Commissioner Thielen.
Aye.
Commissioner Becker.
Aye.
Chair.
Chair votes aye, no opposition or objections. The motion is carried. Item number, let's see, where are we? Number 6, consideration and adoption of legislative delegation policy.
Thank you, Chair. This is an attempt to put into writing a policy I think we've already been following. The intent here is not to change anything. We recently had a case with a agency that did not have a written delegation policy, and questions were raised and differences of opinion were raised. And so we recommended to that agency that they have a written delegation policy. We felt like it's reasonable that we should have one as well. So the intent here is to make a delegation to staff to be able to submit comments, testify on bills, particularly taking positions that are consistent with past commission policy, where there are changes that need to be discussed right away. It asks staff to talk with either the chair or the vice chair. And where there's substantive changes to policy, we would put it before the commission before taking a position. In the past, what we've done, for example, is we submitted comments on the bill stating that the commission has not yet taken a position, and then made like technical recommendations. So the intent here is to do nothing different necessarily what we've done in the past, but actually to put the policy into writing. We're looking for approval of that.
Questions, comments? Yes, go ahead.
Sure.
Commissioner.
Thank you, Chair. I don't see it covering staff. I see it covering executive director. Can you explain?
Sure. In our rules, we use the term executive director to include executive director and staff. In this case, I'm usually one who does all the testimony anyway, so it's still include, but our rules do expand executive director to include all staff under the executive director.
Okay. Yeah,
Any other questions?
there was one other. Let's see.
I have a question if you're.
Go ahead.
Go ahead.
And I'll,
Go ahead.
Just the departure or significant adjustments from prior commission advocacy. What would be an example? So if the commission kind of had a position and then you wanted to depart from that, you would just get the chair's blessing, even if it, but what if it conflicted with, the commission's known position?
I'm so sorry. I think the intent here is, so say for example, 2 years ago, we proposed a bill that would have increased the maximum administrative fine to $5,000. Let's say through the legislative process that got changed to $3,000. Would we still support that bill? Would we oppose it? What position would we take? That's the type of circumstance where I think I would talk to the chair or the vice chair and say, what do you think? Is $3,000 still better than what we had? Is it worth continuing to support? And we would devise a policy. I think if there was something that was opposed, it was something we previously opposed or taken a position on, we would still continue to follow that policy. So again, there is some level of subjectivity to this, to be clear, right? But as staff, I very much want to be representing what the commission wants to do. And so the intent of checking in with the chair or vice chair is to make sure that we're sort of in line. But again, through the legislative process, there are always these kinds of little changes that happen to bills throughout the process. And having the ability or discretion to respond to that is important. And we just don't meet often enough to be as fast.
I got it. So it's just, but it's within the bounds of what the intent of the commission.
Correct.
Okay, Commissioner Thielen.
Yes, shouldn't on the first page of this, under item 3, shouldn't it say the executive director shall not take positions that? Because what it's saying is, I mean, to me, it seems that we're giving up our responsibility under this one. If the position would represent a significant adjustment to our commission's advocacy, or I don't mind number 2, but number 3 would be viewed as affecting our institutional role. So 1 and 3, I would think that shall not take positions that before consulting with the commission, and number 2 is fine. Because it almost places the executive director in the authority as the entire body, the entire commission.
So Chair, maybe, or if you don't mind me addressing that question.
Sure.
If you look at OIP's guidance, they talk about how do particularly volunteer bodies, but any body take positions on legislative policy. And so there are, for example, like under the Sunshine Law, we will need 7 days to notice a hearing. So if there is a bill that comes up that is substantively altered, just the capacity of the commission to meet, to notice a hearing, to meet, and to take a position is difficult in that type of time setting. And so there are recommended ways to proceed. One of them is to delegate to staff. Second one is to potentially create a PIG specifically for that matter. But even in that circumstance, you need some advance notice of what that matter may or may not be. So here, for example, if a bill that we introduce, say on financial disclosures, suddenly changes, let's say instead of being a bill on expanding financial disclosure, it eliminates financial disclosure, public financial disclosure for any board or commission. Would we want to oppose that? It would be consistent with our policy to say that these things should be transparent. That's a type of circumstance where it would be nice to be able to say it's consistent with our policy that we would like to be able to submit testimony opposing such a radical transformation. So I agree with, the intent isn't to decide policy. The idea is to be able to take action on bills that are consistent with commission's policy. And the idea here is also to make sure that we're checking in with the chair and the vice chair to make sure we're getting approval for that ahead of time.
Chair,
Sure, go ahead.
I think there could be 2 ways we could solve this. And first would be the executive director shall consult with the chair or vice chair before taking a position that represents a significant adjustment to prior commission advocacy, or maybe reasonably viewed as affecting the commission's institutional role or credibility. So I think before those 2, it should be mandatory. And then it could be a reasonable effort on the item number 2. But I mean, to me, this whole thing reads giving the authority of the commission to the executive director. And I just don't think that's what we should do.
So in other words, you want to take out the word make reasonable efforts rather than take that on shall consult.
Yeah.
Shall consult.
Yeah, because yes.
Actually.
And if
Yeah.
there maybe should be a way that as measures are moving ahead for a hearing, that with the technology that we have, the executive director can be texting chair and vice chair to keep them abreast. And if either chair or vice chair aren't available, you could designate one or two of the members, but so we could be sort of technically there at the hearing with them through.
Well, let me ask you a question. You feel comfortable that the chair or vice chair should make that decision, or should it come back to the board?
Well,
I mean,
the downside is that what it would be is that the commission takes no position on this, the amendments, to this measure, because they're not able. So, that's the only downside that I see of requiring involvement to be more direct. I don't think so. I need to have it come back to us. I'm with chair or vice chair, because we would have elected those people and feel comfortable with them being leading us.
well, that's good to hear, yeah. At the same time, we're talking about time as of the essence. We don't mean to need to be.
But see that on the downside, we don't take an official. We have no comment on these amendments until the board meets or whatever. I don't want to give away. I don't agree with adopting this the way it's stated.
You don't agree with the way it's.
No,
Why don't we do this? What do you understand what she's saying? Okay,
I think she's asking to strike on line 30, make reasonable efforts.
Yeah,
So shall consult, you know.
unless, is this pressing? If it is pressing, let me ask Commissioner Thielen to, you know, do the modifications and then, you know, then we can look at it rather than do it today. Is that okay?
That's fine. I'm going to consider the existing policy for purposes of anything comes up in January to still be in place. We will meet shortly after the opening day of the
Sure.
legislature,
Sure.
so we can consider it then.
Yeah, is that okay? Commissioners, what do you wanna? Rod?
I mean, I think I had, kind of the same thinking as Commissioner Thielen, but Robert explained why, you know, my read of it was like, oh, significant departure from the commission's position, but I guess that's not really what's intended here, right? It's like more minor adjustments to like whatever it is that was decided. So I would be comfortable if Robert just went ahead and operated within those bounds. And maybe it's like the wording needs to change a little bit, like it's not a significant adjustment to the commission's policy, right? It's more like a different, you know what I mean? It's like a nuanced sort of approach to whatever it is.
So Commissioner Becker, do you have any objection of having Commissioner Thielen kind of, you know, maybe modify it or massage it a little bit, then come back to us?
Well, so I don't want to like have Robert have to like get permission for everything he does at the ledge, because he won't be able to operate effectively that way.
So I'm sorry, what's your pleasure? I'm sorry.
I think if we could like kind of change this significant adjustment language somehow, so it doesn't read like he's departing from what the commission's position.
So we still have to kind of modify or revise this and.
Yeah, a little bit. I think the intent is the same, but it's not.
Yeah. Commissioner Hong, any objection
I think reasonable efforts is defined in the subsequent line, and you know, reasonable efforts such as timely communication by phone, email, or electronic means would be, you know, allowable. I should be allowable. That's a recommendation to recommend passing this as currently it stands.
So do you want to? Okay, I'm Commissioner Commissioner
Okay.
Stephen wants to maybe massage it or revise it. Do you want to just deal with it now, today, right now? Or you want to give her the opportunity to revise and come back to us with the revisions?
I think everyone should be given an opportunity to comment on things, but in this current form, where this significant efforts are outlined, I'm willing to accept that now, but I defer to you, Chair.
Go ahead.
Commissioner Thielen and Commissioner Becker, would it resolve your concerns if on page 59, line 33, it were to say represent a modest adjustment to prior commission advocacy instead of significant?
That's one help, but why not on line 30, Chair, if I may? Why not remove the words make reasonable efforts to? So it's the executive director shall consult. And put down chair, vice chair, or, why not do this designated, commission, other designated commission member? Because there may be a lead point person among us on a certain measure. So that gives the executive director at least 3 people to be able to contact. Do you see what I mean, Chair?
Yeah, I see it, but I think either the chair or vice chair would be sufficient. I don't think we need
Sure.
a third person,
If
unless we die in office, but that doesn't happen, right?
So, I would just say on line 30, get rid of the reasonable efforts and just say the director shall.
Make it
and-
mandatory.
Yeah,
So for me, I actually prefer he not need to consult with anybody, because we're all different people, we all might have different perspectives. And Robert's supposed to be taking our collective sort of guidance and operating within those bounds. And, any one of us, even if it's the chair, doesn't necessarily, in all cases, speak for all of us, right?
So which is druthers in regards to this?
Not have to consult, what is my kind of,
So the word is.
yeah,
take the
because
word-
these things happen real time over there, right? It's like you could just be in a meeting where it's like, take this or leave it, and well, what's he gonna do?
So I'm getting from you, basically, we may not even need this, let's let him just do his thing and, with
Within-
discretion.
Within some boundaries, right?
So how would you word it then? I guess that's the question, how do you word it?
Well, it shall not. Maybe it's like, the ED shall not significantly depart from prior commission advocacy.
I think the discussion shows that there's enough variability in opinion that probably should be, thought about.
I'm
a little
sorry,
bit.
Rob.
I
Commissioner,
think
say it
that the
again.
discussion shows, I think the discussion shows that there's enough variabilities of opinion on this issue that we probably should rework this policy and maybe having Mr. Harris get together with Ms. Thielen and, using that as the initial thing. There's no direct time requirement for this. Is there, Robert?
Is it time of the essence to get this passed is what it wants to.
I think this can wait till our January meeting.
Do you heard that? This can wait till our January meeting?
Yeah, so I think that, maybe talking to Ms. Thielen, and having, clearer discussion. I'm as it's stated, I don't oppose the policy, so I don't feel strongly, but I think that we should have, some of the commission members be able to put their input into this process.
Well, let me ask the commissioners, so I don't want to belabor this. Is there any objections for us to defer this into the next meeting? Then Commissioner Becker and Commissioner Thielen can work out the language with Robert or the other Robert, your Robert, that Robert. Is there any objection to that? Because there is no rush to this too, and January is okay. Is that okay, Robert?
Yeah, it's with
All right.
Robert, but all right, but kidding aside, it's fine with me.
You're not gonna be in Japan, are you?
No, I am in Japan now.
Oh, I know
All
you
right.
are.
All right.
But anyway, any objections that we defer this into the next meeting so that Commissioner Becker, Commissioner Theda, or any of the commissioners can work with Robert in regard to the language? Any objections to it? No objections? No objections. Okay, why don't we do that? Okay, thank you for your input. All right, with that, let's move on. What do we got?
So
Oh, meeting agenda. Is that right?
correct. So just asking the commission, I'm not sure actually if this is something that needs to be moved on, because I think it's a matter of procedure when we meet. But for purposes of letting the commissioners weigh in, they want to change any proposed 2026 calendar. This is an opportunity to do so. The idea would be is we keep our same meetings on the third Wednesday.
Do we have to, I know we do this in my neighborhood board because I'm the chair. We, for the next year, we actually say when we're gonna have a recess. And normally we have a recess during Christmas. Do we need to do that? I mean, the proposal was to not have a meeting this coming December. Do we have to put this in for 2026 or would you wait?
So I don't think we have adopted a specific meeting calendar. We simply notice each month. So because we haven't adopted, I don't think we actually have to take action. It's incumbent on the commission and chair.
We don't have to take action.
So, I think it would be entirely appropriate to announce that we're not meeting in December. I think for purposes of 2026, I would still recommend keeping it on the calendar. For example, if we need to discuss proposed legislation still, we have the hearing reserved, the meeting reserved, but if, we don't have substantive business to conduct that month, we don't necessarily have to meet.
Okay. Any objections, just leaving as it is? We have a meeting every month as scheduled for 2026.
And it's
Commissioners?
it's the same issue. It's the third Wednesday, so it's not a major change. So I would support this.
So come at me. I'm not gonna be around anyway. That's last. All right. Okay, no objections. We'll just.
Half the year you won't be, and maybe more.
Hey, what can I say? And what else we have? No, that's it, right? Or that,
No, sorry.
we got something else more in the meeting calendar?
Yes, Chair, we have a reoccurring item again. I'm sorry, I said we were almost done with it, but we weren't. We have the Akana, the Hawaii State Ethics Commission, still on the agenda.
Yes.
There are 2 civil cases that are still ongoing. One is a case where Akana had sued the Hawaii State Ethics Commission and Daniel Gulak in his official capacity, essentially like a collateral estoppel lawsuit. And then they filed an appeal, so that case has been not acted upon, essentially been stayed. And so it is one that is going to need to be dismissed, hopefully. And secondly, there is a collection action by the AG's office where they are attempting to collect the attorney's fees that Akana had accepted. So if you remember, under the ethics code, we can assess fines. The AG's office has the power to go after any benefit, granted because of in this case, a unethical gift. And so they are electing to do so in this case that's referenced here. I am noting the attachments 1 and 2 indicating, unfortunately, that Ms. Akana has passed away. I would recommend going into executive session just simply to talk about how that impacts the legal status of these 2 cases that are still ongoing. And so I recommend, if there is, a motion to do so, to go into executive session.
Any objections? I'll entertain a motion that we go into executive session. Moved by Commissioner Thielen. Is there a second? Second by
May
Commissioner
I be
Becker.
specific, just for purposes of the record, that this is a convening of executive session pursuant to Hawaii Revised Statute Section 92-5A4 to consult with the commission's attorneys on questions and issues pertaining to the commission's powers, duties, privileges, immunities, and liabilities.
With that addition to the motion, roll call.
Starting with Commissioner Hong,
Aye.
Commissioner Thielen,
Aye.
Commissioner Becker,
Aye.
Chair.
Chair votes aye, motion's carried. We will now be in executive session. What? I have
A brief general summary of matters.
Oh,
Very
okay.
executive session.
So I'll just make sure you do that. I'm tasked with, just summarizing what happened in executive session without divulging confidential. We discussed the lawsuit that's still pending, by Akana against the commission and Gluck. And what the Attorney General's office plans to do, which will be remain confidential. And also in regards to the collection of attorney's fees that were received by Akana by a private source. So that's what we discuss, and we'll see what happens in the future. Anything I missed? Okay. All right. We're now back in a regular session. Anything else we have? Oh, if not, adjournment.
Oh, so moved.
So moved by Commissioner Hong. Is there a second? Second by Commissioner Thielen. Any discussion? Roll call.
Commissioner Hong,
Aye.
Commissioner Thielen,
Aye.
Commissioner Becker, Chair.
Chair votes aye. Motion's carried. The time is now 10:09. Should we just take 10 minutes to come